Today we will walk through a generally unpleasant but important legal topic, end-of-life decisions. Would you like to let the world know ahead of time how you want to be medically treated when that time comes? You would make these wishes known in a living will, also known as an advance directive. Through a living will, you are able to give written legal instructions about your medical care when you are unable to make these decisions for yourself or cannot communicate these decisions. These decisions aren't easy, but they can help avoid unnecessary suffering and relieve your caregivers of some burdens during a time of crisis or grief. Without a written document, your wishes may be a mystery. Family members and doctors are left to guess what you'd prefer in terms of treatment. This can lead to disagreements, even court battles. These end-of-life decisions aren't just for older folks. Things happen unexpectedly. Accidents and illness are not reserved for the older generations. So it is important for all adults to consider preparing these documents. So what's involved? Well, every state has specific laws about these directives, and you will want to be sure you comply with the law and properly sign the form. But in general, your living will details the medical treatment you want and don't want to be used to keep you alive, as well as other medical treatments such as pain management or organ donation. You can make these choices freely based on your feelings of being independent versus dependent, and your thoughts on circumstances where you'd like your life to be extended as long as possible versus dying peacefully. You can have a conversation with your doctor about the particular methods that can be used, such as CPR, ventilation, tube feeding, dialysis, comfort care, etc. Knowing how these work may help you make informed decisions. Many times, if allowed by law, you will name an agent who can advocate for your wishes and see that they are being followed. This is referred to as a medical or healthcare power of attorney. Keep in mind that your living will can take effect as soon as you sign it, but won't be used until you can no longer communicate your wishes about treatment. You can also revoke a living will at any time you wish, and it will cease being effective when you die, with the short exception of directives for the treatment of your body for donation, autopsy, etc. When your living will is signed, witnessed, and notarized, it's a good idea to share a copy with your doctor and give a copy to your healthcare agent and family. Keep the original copy safe, but you can share copies with anyone who needs it. In that moment of crisis, it's important that people know ahead of time that you have a living will. And once it's signed, pull your living will out periodically to review it. Do you still feel the same way about these decisions? Has anything in your life changed since you signed it? Keeping up with this form will offer both you and those you love some peace of mind.